Hey everybody, welcome back to our slightly delayed telecast of our weekly podcast. My name is Patrick Tan, General Counsel for ChainArgos. With me as usual every week, Jonathan Reiter, our CEO and Chief Data Scientist. Sorry for the delay, but that's because we were in Bucharest as part of the annual Digital Innovation Summit and the inaugural Blockchain Intelligence Forum. We'll have more details on that. Just check us out on socials and you'll get more information on that great event. And this week, what we're going to be talking about will be the CFTC guidance changes that happened sometime like the end of last month, and we haven't really had an opportunity on this show to talk about that. The money laundering guidance changes. This was basically, I think it was the WAPO that...
Which it's a DOJ memo.
Yeah, it's a DOJ memo that was leaked to the WAPO. I think it was meant to be an internal memo. It was an internal memo. At least it wasn't meant to be. It wasn't meant to be circulated, I think. But I think the intention was that it was intentionally leaked or something. Long story short, memo is pretty readable. You can find it on public sites, and just a little bit of information as to how they're going to be treating some of this stuff moving forward when it comes to crypto assets. Finally, we're going to talk about the SEC's statement on stablecoins and securities as part of the Trump administration's sort of the crypto-friendly shift. So let's talk about the CFTC guidance changes. John, you got the download on that?
Yeah, okay. So I guess these are three different government groups clarifying their positions. As we'll see, there's no coordination here.
Well,
They're all completely different. So the CFTC is essentially rescinding some additional requirements for crypto-related commodity futures. That's what the CF stands for, which, yeah, fair enough, seemed very out of date. So there have been various, there's Bitcoin futures and a number of other things going back, I think, to 2018. And there were, at one point, several traditional exchanges and no sort of crypto-y sort of exchanges. So the CME and the CBOE, which are both old, very large exchanges, had a couple of different futures. The CBOE gave up, or there was no volume. They stopped. CME volume was small for many years. Remember, this is like 7 years ago this stuff started. And there are a number of other futures now, and there were additional requirements imposed on things. One of them, the most sort of onerous, than the one that's being withdrawn that's most meaningful, was that having a market surveillance agreement with I think it was called a market or venue of significant size. You had to have a crypto exchange that would help you do some kind of surveillance on the underlying market. The theory, I think, was that most crypto is traded offshore, and so they had no idea, what was going on in the cash market that the futures were supposed to track. There were ICE futures at one point that were actually deliverable. The other futures are cash settled, whatever, all kinds of futures. So all that's being removed, and they're just running sort of standard markets now. All the other special requirements. 100% of that seems reasonable to me.
Yep.
Those requirements always seem stupid. It is definitely true that most of the volume in the underlying crypto things is offshore. That's also true for lots of commodities.
Correct.
It's arguably true for a lot of equities because, ADRs and multiple exchange listings, at least a reasonable fraction occur. Now, you can argue those are regulated exchanges, but, a lot of these crypto exchanges have always had licenses in some country. It's just been a country where, there probably wasn't a stock exchange. Right? So whatever you think of the Seychelles or the Marshall Islands for having a license, or a lot of Caribbean islands for having a license, there is no stock exchange. So it's not like there is a stock exchange sort of thing to compare it to that it's just, not applicable, right? So, you can't complain their stock exchange is bad. There isn't one. The surveillance is commodity market. OTC oil, industrial metals is
It's a thing.
Completely
Yeah.
it's not that it's unregulated, it's that nobody attempts to regulate transactions in physical aluminium. That's just not a thing in really any country. There may be taxes and there's probably tariffs on it now, but whatever. Those are separate. Not that kind of regulation. So all that's being rescinded, which is completely reasonable. It would be reasonable if more deliverable underlying futures came back. It's unclear when and if that will happen. ICE's attempt to do that via BACT just went nowhere. BACT has been nowhere for a long time. There were talks about BACT being bought, whatever. The KYC requirements for using BACT meant that no one used it, which tells you a lot about the state of the market 5, 6, 7 years ago, but whatever. So that's all back to normal. It's unclear if that will make a meaningful difference. It should remove a little bit of compliance cost for the CME, for people for whom these are not major issues. I don't know if this means that people like Coinbase and Kraken would then run a really traditional style futures market more clearly. I don't know. I continue to think that running a perpetual futures market for retail usage is going to face regulatory problems because the disclosures for the funding mechanism are extremely challenging. And I say that as someone who has tried to do that for products before, because that's been a thing for far longer than crypto has existed. And I think that banks and whatnot will struggle to have a hidden, periodic, sort of non-transparent funding mechanism is a problem because you will have difficulties. But the surveillance thing was never really relevant, and I don't know where it came from and why they wanted it, and that's the end of it. It did produce that fascinating Gemini settlement where they were the pricing source in the surveillance sharing agreement with the CBOE, and it turned out that it was all internal wash trading with the Gemini twins' own assets underlying that they were lying to people about. They agreed that they were doing that and paid a fine. It was a fantastic set of filings we talked about before. So, yeah, that whole cycle's closed. All we got out of it was comedy, which is a good summary for a lot of these things.
Okay.
Just worth it.
The money laundering...
So do you want to do the DoJ next, or you want to do the SEC next?
Oh, let's do the SEC then, because it's closer to the
yeah.
CFTC. Yeah, let's talk about the SEC statement on stablecoins and securities. Mind you, these are the statements.
Yeah. So there have been complaints about lack of clarity for a long time, and the SEC issued 2 statements, one of which is meant to establish some clarity around stablecoins, and one around sort of what is a security and what not for crypto assets, sort of in general. So these are not changes in the rules as written. So I think maybe we'd do the crypto securities thing first
before the stablecoins. Yeah.
So the securities one is really interesting in that it's amusing to me that this is considered clarity. So it's a document that's it's long. It's got a lot of examples, and it's just a recitation of examples what people have done in the past. Right, so these are things people have done. These are ways people have chosen to register, what they've chosen to register. There's an issue or whatever it is. So they say, subject to the conditions of the transaction, here are things people have chosen to do in certain conditions. It's a great book report, and I don't mean that in a derisory fashion, because it's nice to give people a summary of what's happened. For traditional securities regulation, that summary is achieved by engaging a competent securities lawyer. Because they know those things. But if lots of people want to do this from scratch, from first principles, such as it is, this gives you a great book report to start from. That's fine. It's the 8-hour. Well, trace the references. It'll probably take you a couple days to read up on people who think Google is a sufficient legal education. That'll get you somewhere, right? And it's nice of them to provide that collection of activities. Nowhere does it actually provide statements where you're exempt. They don't even describe circumstances in which they think you're exempt. They just say, here's a bunch of circumstances and stuff people have done, actively done, that we accepted, went along with to comply. Okay, that's fine. It's definitely useful as book reports are useful. Summaries, systemization of knowledge, the academic sort of version. These reports are often quite useful, giving a framework in which people have done things. So okay.
I do say though that I think it might be challenging from their perspective to actually say that these are the situations where somebody would be exempt. I don't think they're at that stage yet.
I don't think that there are circumstances that are different, right? So the rules are not any different. If you look at what's been put together, this is, I guess, meant so people can read it and say, I look like this, so I'm going to do what those people do. Yeah. And because it was in their document, I won't get in trouble. That's standard common law precedent regulation for enforcement. Like, that's fine. By saying this statement is useful, you're saying regulation through enforcement is a good system that I support and I'm using it. No, because that's what this document is.
No, but the irony is that that's what the system is. That they haven't changed that system at all. Yeah,
these are just, it's a recitation.
This is not. The United States hasn't gone from common law to civil law overnight because of this. Yeah,
this is intended for the people who don't recognize that sort of reasoning and regulation through similarity. Similar precedent is correct. So here you go. Enjoy yourselves.
And to be fair, like if you fall within those categories and you get the whatever treatment that has been the case in the past, and you fall within those categories, and then
it's not even it's like it's really specific.
Yeah, very specific examples. So let's say, for instance, by some happenstance, you fall into the exact same situation that has been described before. And you should, and for some inexplicable reason, you're treated in a different way. You can actually take this to the court and say that, hey, this created the expectation that I would
you
be
can
treated
do
the
that,
same
but
way.
then as the document makes clear, if the facts and circumstances of your transaction
Correct.
are different, then you could be treated differently.
Correct.
So if you're identical to an
Yeah,
example
right.
that's here, they still haven't provided these guys with a get-out-of-jail-free card. They've simply said they haven't taken action as of yet. It would be surprising,
Yeah.
having said that, there are more than 0 examples where the government statement of what happens is based on believing what the team said and is not accurate.
Well, that's a whole can of worms that we'll go into when we have time.
I'm just saying that there are examples the government has given where their description of what's happening factually is categorically false because they believe what the team said.
Yeah, but again, too
I'm not surprised by that. No, there's not going to be adjudication of
Yeah.
that. So the advice for teams is to claim that you fit like the group in this document that has as little requirement as possible. Find the simplest, easiest thing, whether or not that's true, and no one will investigate.
Yep.
So that's legal advice.
No. That is not legal advice. He's completely kidding. We're not providing.
Qualifies.
No, you're not a lawyer. That's not legal advice. We're not making any statements.
It's unlicensed legal advice.
It's not even unlicensed legal advice. It's just a joke.
good
Don't take
advice.
any of that. It's not. It's just a statement.
advice.
It's not advice.
It's worth what you paid for.
I want to make it very clear that nothing he has said is advice. He's
It's
just
a
mouthing
suggestion?
off. No. It's just your opinion.
Okay.
So moving on.
It's accurate.
We'll find out. Moving on. Money laundering guidance changes. What with the DOJ?
Okay, so the U.S. Justice Department. I don't. It's interesting. Your read that this was not intended to be public. My read is that they were going to make a statement, but that it was just leaked first. Who knows what's going on with this sort of government communication process in the United States at this point.
I think it was intended to be leaked. Yeah.
Oh, okay. That's also.
Yeah, I think it was intended.
I mean,
to be
I'm
leaked.
sure they knew that whoever it was handed to in the crypto space would have leaked it.
Yeah, of course. So this is basically the enforcement priorities of the DOJ. It was I think passed down by the AG.
Yeah. So there's no changes in the law, and many of these things have very long statutes of limitations.
Correct.
So this is a statement about what the priorities of the administration as it stands today are,
Yeah.
which is not the same thing as saying, no, I mean, just to be clear to people, it's not the same thing as saying this is no longer illegal, or this has been pardoned, or this has been, whatever. Congress has done something to change the rules. So this could be changed at any time, and you can't really use this as a defense. You can use this as an expectation of what will happen.
For now.
Well, until it's rescinded.
Yeah.
Which is definitely useful, but it's important people understand how long and how risky you want to be as a function of how strong the guarantee is. And here the guarantee is so long as this is the Attorney General, this is what the priorities are, and they don't just decide for some reason to go after you anyway, because this has no force of law. There are far more crimes committed than are ever found, ever investigated, or ever convicted in every country forever, because that's just the way the world works, and they have to prioritize. So this is about their prioritization process. Whether or not that's right or wrong, that is true forever, right?
Yeah.
'Cause you can't spot everything. So they're essentially saying that crypto products, somewhat uniquely in finance, will not be prosecuted for money laundering unless it was willful. Or you have to have the intent to do that, and that the sort of strict liability standards will not be applied to crypto products. They will presumably continue to be applied to non-crypto products. So one would expect all non-crypto products to simply use a blockchain so that they're treated the same, which is fair.
Yeah.
It's something we've said for a long time.
Yeah.
Banks should simply fire their compliance department and move things to a blockchain if this is the way it's going to work. So that's good. That clarity is useful. They also say that won't exactly apply if there's terrorist or state actor financing, but it's not clear if that means if you had no intent to launder money but laundered money for North Korea, will go after you anyway, or if it means the only people we'll go after are people who have intent to launder money and launder money for North Korea. Right? So if you're facilitating capital control evasion on purpose, that also may not be necessary. That may not be pursued. It wasn't entirely clear. It is clear that if you have intent to launder money and launder money for, I think they include drug dealers, terrorists, whatever, state actor type things, that will be a problem. And then it's a little bit unclear whether people who end up with those bad folks using their system but didn't intend to will get in trouble. And as long as bad folks don't use your system, it doesn't really matter. So you're kind of not going to be pursued. Which again is fantastic because it gives you an order in which to sort of tells you how to do your surveillance, how to do your defense, such as it is. Defense not the right word, but your evasion has a bad feel to it. I just sort of mean what you have to screen for, and then when you have to submit the suspicious activity report, such as it is, right? Because it seems like the way to comply with this, and this has come up in lots of market abuse type prosecutions in the U.S. and in the EU. You just need to say into the telephone on the recorded line as many times, I do not intend to launder funds. I do not intend to launder funds. And then submit reports that this looks suspicious to whoever you can submit them to when they come in. And then you should be fine, because that should work as a defense that, you
did not intend to
do it. And I mean, if that doesn't work, nothing will.
Yeah.
Right? Put that in your comments, put that in your documentation, and submit reports. Because if you just write that in your code and then never submit any reports, that is, you can argue that that's a sham. Whereas if you're submitting reports, you're going to struggle that seem competent and well-intentioned, whatever. That should be more than sufficient for you to convince a jury that there's no problem.
I think it's important to know, as John rightly pointed out, this is just an enforcement priority. So just because the sheriff in town doesn't want
7 years later, somebody could decide.
And the thing about these types of offenses.
And that's true for all this stuff. None of these things are passed by Congress. So a different prosecutor could just take a different approach.
Well, a different administration could change everything.
A replacement attorney general could have a different attitude.
Yeah, I mean, enforcement priorities.
This attorney general could change her mind, although that seems like
unlikely. But enforcement priorities are not carte blanche to. It's not the purge. Let's just put it that way. It's not the purge where you can go and do anything one day, no laws. It's just. This is not a priority of this administration. We'll get to it when we get to it.
It's telling you where to focus your efforts and don't push your luck, because you got plenty of space here to effectively to launder lots of funds for lots of people without any problems. Just don't do certain things in certain ways.
Don't serve certain customers.
Which is fine.
Yeah.
And it should push most of normal finance to use blockchains, even if only as databases, because that should be sufficient to achieve this deprioritization of enforcement. I mean, if TD had done what they did on a blockchain, they would not have been prosecuted.
They would have reached exit velocity.
No, I mean they should have used a blockchain.
Well, they didn't know.
No, I'm saying, but that's
they didn't have this thing
recent case, which is fine. I mean, the government can choose to enforce whoever it chooses to enforce. That's what the executive branch does. So fair enough. It's pretty straightforward. So this should help blockchain adoption for traditional finance, not decentralized, just the usage of blockchains in general. Because that type of database has different regulatory treatment, which is something some people, or frankly very few people, have asked for. All of the regulators have spoken about how their policies were intended to be technology neutral, and this one is absolutely not technology neutral. So that's what I meant by there's some interesting inconsistencies here. The SEC intends to regulate in a technology neutral fashion, and the Justice Department intends to regulate in a sort of technology dependent fashion, which is kind of odd, right? So you can run your stuff on a blockchain, in which case you're still going to have to do all the securities things. You can't fire your whole compliance department, or you have to keep the SEC and perhaps CFTC facing portions, but you can get rid of the sort of criminal defense portion, which is, I'll be speaking totally honestly, a tiny fraction of the bank compliance budget, right? Most of people, it's not worried about that because that's not usually the problem, right? The procedures are normally such that that's not really the issue. But actually, now that I think about it, that's normally because the KYC process and whatnot isn't considered that kind of part of compliance, but prevents that from being as much of an issue. Yeah, okay. So if you consider that it lets you delete a lot of the KYC stuff, then you're probably all right. You are presumably going to have to put disclosures in your now clarified SEC filings that your business is operating pursuant to this Justice Department memo, so you don't suffer an investor lawsuit if the Justice Department changes its mind in the future. So that's I guess I'm not allowed to call that legal advice. We can call that a suggestion. You should make sure that your SEC filings include the risk disclosure that if the Justice Department changes its enforcement priorities, you could have a criminal problem here. But so long as you don't, it seems like a reasonable business. And frankly, that does seem like a reasonable risk disclosure. We believe this is not going to be prosecuted as a crime, so we're going to go ahead and do it. And if they change their mind, it could be a problem for investors. Buyer beware. I mean, those kind of statements are why the SEC exists in the first place, to make people do that. So do that. I mean, like that it's all kind of working in concert. It's just kind of, it's working in concert, not in a way anybody foresaw, or in the 30s, 40s, but it's all, the pieces still fit together. The system's pretty flexible.
And on that note, thanks for tuning in. You get a double bill this week. We'll be back again on Friday. Oh, well, not Friday. It's Good Friday this week. So maybe Thursday. So we'll get back to you again with the next episode. Thanks for tuning in. Remember, not legal advice. Suggestions, opinions at best.
Friendly advice.
No advice. No advice whatsoever given on this show. Thanks for tuning in. We'll see you again soon. Take care. Bye-bye.